session will be hosted by Mr. Kaveesh Nair, Associate at Vardharma Chambers, and the topic of his speech is International Commercial Arbitrations in India, from Agreement to Enforcement. Please give him a big hand.
Evening now. I hope everybody is having a good time. I wanted to speak about this topic, and now I've met some absolutely blistering arbitrating lawyers and arbitrators who are sitting there, and well, I'd just like to get on with how this works in India. So the context of arbitration in Indian context, how arbitration works as opposed to abroad and foreign jurisdictions, is slightly different. When you're talking about institutional arbitrations and ad hoc arbitrations and how you appoint and how you go about your agreements, there seem to be certain disconnects when it comes to assisting councils and companies who are entering into international commercial arbitrations, and how they go about those contracts, what their expectations are about those contracts, and how they expect the dispute resolution to go forward, and how it actually does eventually go forward. So the Indian Arbitration Act is divided into 4 parts. Part 1 is your sections 1 to 43. They deal with arbitrations which are seated in India. The venue versus seat and the location of the arbitration becomes extremely important, and I will get to that in further slides. The second part of the Arbitration Act deals with enforcements of foreign awards. Now this is for arbitrations which are seated outside of India, and the second part only deals with the question of enforcement. The third is conciliation. Conciliation is also guided by a statute in India. It needs the consent of both parties, but we will not be addressing that today. And the fourth is, of course, supplementary provisions, which are miscellaneous powers that courts have. So in international commercial arbitrations, there are, of course, international would mean that you have at least one party which is not based in India. Now that could be residents, their incorporation, their central management, whether it's a foreign government, but at least one party to the arbitration should be based outside of India. Domestic arbitrations, of course, as the name itself suggests, you have all parties which are based in India, and then foreign arbitrations. Now, in terms of foreign arbitrations, I just said that only part 2 of the Act applies. Now, this has certain caveats. The caveats being, you have a few sections such as section 9, 27, and certain subsections of section 37 which also apply to foreign seated arbitrations. Why? Section 9 deals with interim relief. What is interim relief? That is, if you have a foreign seated arbitration, for example, you have 2 companies which are contracted, which are based maybe in India, one of them may be abroad, but one of the companies wants to approach the court for interim relief. It may concern a share purchase agreement, and you're worried that the other party might alienate its shares. What do? You can't approach an arbitrator in Singapore in time. You approach a high court. You approach a high court for a relief under section 9, and then within a certain period of time, your arbitration has to begin. That is why that exception is made that a part 1 arbitration provision is also applicable to foreign arbitrations. Now, in your agreement, I cannot stress how important this part is regarding the clause in your agreement. I'll just let everyone have a look on what the important things that I want to highlight from personal experience and something we're dealing with on a daily basis. So I know already a few people who are dealing with arbitrations. How many of you have dealt with Indian-seated arbitrations, arbitrations which are seated in India? And how many of those were with government institutions or government bodies? So I'm sure you know that there's a very interesting clause that government bodies put in their appointment procedure, which is that they will have the power to appoint the arbitrator. Now, 2015 amendment comes in. Before 2015, they were even more blatant with it. They said that we will be the arbitrator. Then they finally started changing it after 2015. They said, we will appoint the arbitrator. And that also led to situations where they had their own panel from which they would choose, and the question of impartiality which was raised by Sir. So from the get-go, we had a situation where partiality and impartiality of the arbitrator was in question. So then came the judgment of the Supreme Court in Perkins-Eastman, which said the person who cannot himself be an arbitrator also cannot elect an arbitrator. So this is something to keep in mind in India, even if you have signed a contract which says that the opposite party has the power to appoint an arbitrator, you can still go to the High Court, you can still say that we want an impartial appointment. The second is this, the procedure. At the stage of Section 11, the Section 11 application is basically how you approach the High Court. You tell the High Court that this is our dispute, this is the existence of the contract, and all the High Court has to see at that level is whether you do have a valid clause, and if you do have a valid clause, whether it is not ex facie barred by limitation or arbitrability, in the sense that you can't take a 1919 contract and try to enforce it in 2011. Something that is completely undisputable is what the High Court will look into. Okay, and the next thing. Now this has produced some absolute legendary judgments from the Supreme Court of India and the High Courts, if I may say. The debate between seat and venue. Again, cannot stress how important it is for your contract to absolutely be clear on what the venue is and what the seat is. Your seat is the anchor of your arbitral proceedings. Everything is tied to the seat. When you go to a court, when you approach the court under any provision, where you go to a court under Section 9, anything you do, you have to initiate that before the seat. The venue is differentiated. Now, you have to keep in mind, the word seat actually does not find mention in the Act. It is only through judicial interpretation that this difference is culled out. In Section 23, then you have the venue, which is the convenience of the parties. Now, your seat may be in Delhi, but your venue may be in Mumbai. So tomorrow, if you're unhappy with what happened in Mumbai, you can't go to the court in Mumbai, you have to go to the court in Delhi. And that creates a lot of confusion. In fact, there have been a lot of judgments, and finally today we are in a situation where we have judgments which say that it cannot be an interchangeable use of the words between venue and seat. You have to see the intention of the parties, you have to see where the parties anchored their proceedings. We had a case where the governing law was Indian, the act that was applicable was Indian, the challenge was to be made in India, but throughout the arbitration the venue was London. And now, when they came to the Bombay High Court for relief, initially the Bombay High Court was of the opinion that no, we do not have jurisdiction in this case, which was finally clarified by the Supreme Court that no, what you have to see is the intention of the parties. So you have to keep in mind where you will go, which court you will go to. That is very important when you're looking for relief. And again, these are all Part 1 arbitrations, India-seated arbitrations. None of this is applicable to your foreign arbitrations. Now you finally get your arbitrator appointed after a great fight, especially if you're contracted with a government organization, because they will make it hard for you to appoint an arbitrator. And like ma'am over there had a very big complaint about the tax department. That's same for pretty much all departments. So once you do get to the stage and you manage to appoint your arbitrator, in India you will see very rarely are there references made in Indian seated arbitrations to institutional arbitration. Now, we've had Justice B.N. Sri Krishna's committee who made an entire comment on it. Comment is kind of downplaying it a little bit. It was a 100-page report that he had produced. And through that, he essentially highlighted that India does not have any credible arbitration institutions, or didn't used to, at least back then. This is 2017. Like, we have SIAC here, we have DIAC in Dubai, London. They're popular seats of arbitration. India did not have any institution at that time. So, and essentially, even today though, one thing that is to be, again, I point out, even in government contracts, you contract a government agency for energy contracts, construction contracts, even they do not have any references to institutions. They want ad hoc arbitrations. Reasons I'm not at liberty to discuss on stage. Now, certain developments have taken place. We have our first International Arbitration and Mediation Center, which my friend tells me is now finally up and running. We have cases going on over there, and I hope you do manage to get that empanelment eventually once that comes around. Then another very dedicated arbitration center that will come up will be in Gujarat, in the gift city, that will only deal with maritime disputes. Now you come to the challenge. You have gotten through all the loopholes of getting an arbitrator appointed, ensuring that your award is delivered. Then you come to the challenge. Your challenge is, as the UN Citral Model Laws suggest, your challenges can be on very, very, very limited grounds. You cannot challenge an award on merits. First of all, there is no challenge to an award on merits. There can be no re-entering into the merits or evidence of the case. These are the very few grounds which you get, and keep these in mind because a lot of these also apply, pretty much all of these also apply to foreign seated arbitrations when it comes to enforcement. This award can only be challenged within 90 days plus 30 days if you can make out a case as to why. And this award can be challenged only before the seat court. Seat court is important. You have to ensure that it's challenged before the seat court because that is again the question of seat versus venue comes in, and that is where again a lot of litigation goes to waste for a lot of people if you challenge your award before the wrong court. The challenge fails. You have an award that you can enforce at long, long last after, well, let's say a few years at least. Then, after the 90-day period of challenge is expired, you can go for enforcement. Enforcement, sorry. And enforcement will be under the procedure established by the CPC. Now, why is this important? This is important because where do you file for your enforcement? Where do you think you will file for an enforcement? If anybody who's worked in arbitration matters, which a lot of you have, where do you file the enforcement? Anybody? Which court? Which high court in India? Correct. Wherever the subject property is located. That is why the procedure under CPC comes into play. And why this is again important is because prior to a judgment of the Supreme Court in Sundaram Finance, what used to happen is parties used to approach the seat court saying, I am filing before the seat because the seat has the jurisdiction. You transfer this enforcement to where the assets are located. And the assets are located here. Okay, I have got a sheet of his assets. I've got a sheet of his whatever properties he has. You transfer it there. Now, certain courts said we have no jurisdiction to entertain something like this. You file it before this court or that court. We had a lot of conflicting judgments. Sundaram Finance comes. Sundaram Finance says you can file it directly where the assets are located. And you would think that is the end of the dispute. No. Again, there are conflicting judgments of the High Court which are confused about whether you can file it before the seat court or not now. Delhi High Court says you cannot file it before the seat court. Delhi High Court says you can only file it before the asset court. But the Bombay High Court says you can file it anywhere. You can file it at the seat court and ask for a transfer, or you can file it directly before the assets. So play it safe, file it where the assets are, be safe. Just don't go to the seat court because just do what the Supreme Court says, go to the assets. Do not file it before the seat court. Now, in terms of seem to have run out of battery. Am I audible? Yeah. Okay. So in terms of part 2 arbitrations, oh, it's working now. Oh, thanks. Part 2 arbitrations are your foreign arbitrations, your awards that are rendered in foreign jurisdictions. Foreign jurisdictions are your New York Convention, Geneva Convention signatories. New York Convention for the most part now. When you bring a foreign award from a New York signatory, I'm not going to say that everybody is a signatory to the New York Convention. When you bring a foreign award to India, it again, just like the challenge was very difficult, challenging and enforcement is even more difficult. When you bring an award to India, you have to file it before the High Court where the assets are located. We've established that. And importantly, you can only challenge it again on very, 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 very limited grounds. The ground of public policy is to be construed even more narrowly when it comes to an enforcement of a foreign award. Even the Supreme Court is encouraging smooth enforcement of foreign awards. That being said, execution proceedings will take time. You cannot do anything about it. One of the biggest qualms people have, especially foreign international companies have, anybody has, is with understanding how long it takes for an execution or an enforcement petition in the High Court. That is something you will have to keep in mind. That is kind of something your lawyer can't do much about. Now finally to the procedure of enforcing of a foreign award. You get your foreign award, let's say in Singapore. You get that foreign award, you file an original copy or a certified copy along with your agreement before the High Court, the relevant High Court as I pointed it out. Again, within 3 years, this was also recently decided that 3 years is your limitation for enforcement of a foreign award. And then once you have filed it, the other party is given an opportunity, not given an opportunity, they have a right to file objections under Section 48, again, to be construed in very, 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 very narrow terms. Also, The executing court is only the executing court. The executing court will not touch on the merits, will not touch on anything. It could be the worst award ever passed in the history of awards. The executing court cannot do anything as long as it does not interfere with the grounds I had mentioned before. Then there was another confusing factor before the High Courts earlier, is whether the enforcement and the objections will be taken up either together or will they be two separate proceedings. We have clarity on that. They will both, the maintainability of the enforcement and the objections are a common proceeding. They'll be decided together and the enforcement will proceed at the same time. And finally, of course, you get to the stage where your award is either enforced or refused. So your challenge to an award, suppose you are someone who's suffered an adverse award, what you have to do is challenge that award in the jurisdiction it has been passed. The threshold that has to be crossed in the foreign jurisdiction where the award was passed. If you win there, then you can tell the court in India that, okay, that award has been set aside in the jurisdiction it was passed. Unless you have that, you do not get to challenge that award. And then finally, of course, your enforcement is allowed. And then again, the long procedure of attachment of properties and so on and so forth begins. So that was me. I hope that was helpful on how to go through your appointment process all the way through till your enforcement process. Just a few things to remember. Be very clear on your procedure for appointment of arbitrator. It has to be completely impartial. Be very clear where your arbitration will be seated. That will decide everything. Institutional arbitrations, good, best. It will be more time bound. It will be governed by a very strict set of rules. Then you come to your challenges, enforcement. Be very careful where you file your enforcement. Always file it before the assets, whether it's international or domestic. And yeah, just always remember limitations. Do not sleep on your rights. That is one thing that I cannot emphasize enough. So if anybody has any questions, or I'd like to entertain them if you have time. Do we have time? Okay, we can, anybody has any questions, any discussions we can have afterwards. So that's how you go through about it. Thank you.